You're listening to a Kumaran podcast.
Hi, welcome to our podcast series, English Law in 10 Minutes. My name is Katherine Hensby. I'm a director here at Kumaran in our banking and finance team. And with me in the studio today is Alex Wulff. Welcome, Alex.
Thank you very much, Katherine. Nice to be here. Very quick introduction. So I'm a legal consultant in Kumaran. I specialise in banking and finance and also corporate and do some M&A as well. And I'm here to talk to you about express and implied terms.
So what exactly are we going to talk to you about today? We're going to think about express terms and what that means in terms of a contract. We're going to have a look at implied terms and the likelihood of success when you're trying to read something into a contract which isn't expressly stated. We're going to talk about some exclusions to that and whether it's possible or not to contract out of particular implied terms. And then we're going to have a look at some drafting considerations.
Absolutely. And I mean, maybe just to take it right back to the basic, what do we mean by express terms? Well, an express term is a term that has been, surprise, surprise, expressly stated between the parties. Now, that can either be written down or it can be orally.
And typically it's written down. It's typically what we would see in the body of a contract.
Exactly. And if you're asking which carries more weight, in the UK, you're going to look for written down, written drafting. The reason being is we have something called the parole evidence rule, which is that this overriding presumption that if the terms are written down into an agreement, that expresses the party's true intention. And previous negotiations or things outside of the written contract are not going to be given as much weight. Having said that, there are certain terms that are naturally implied into contract. And I think that's probably the wider discussion point here, isn't it?
Yeah, so what are those implied terms? What do they look like? Well, as the name suggests, those are terms that have not been expressly agreed between the parties, but are implied into a contract by law, essentially. So the court will say particular pieces of statute apply, perhaps, or they will look back to precedent if appropriate.
Yeah, exactly.
So a particular party might want to argue that certain terms have been implied into a contract. And I think actually this is really relevant when we look at the Danish position vis-a-vis the English law position. The English law position, the courts will say, well, what's in the contract? Contract is king. Whereas in the Danish context, the courts are more willing and more able to look round and look outside the contract to see what the parties intended.
And I think given that, we need to remember that under English law, we have this almost like sliding scale of success with how lucky you're going to be at getting in your implied term. So if we start at the strongest and the top end, that's what we would say terms implied by statute. These are terms that have their own governing law principles and will automatically be applied into a contract. So look, to give a few examples, we have acts like the Sales of Goods Act, the supplies of goods and services, and maybe closer to home to employees, something like the working time regulations. Some of the terms that are implied here might seem pretty obvious. When you buy a product, you expect that the nature of that good matches up with what you paid for, the description and the quality. If I buy a 30-inch plasma TV and I'm delivered a small 15-inch broken TV, even if the contract is silent, I've got a pretty good argument for implying a breach of a contractual term. Now, even though that you have it implied in statute, there is some ability to contract out of those terms. And maybe we need to just give some thought as to what happens if an express term in the contract conflicts with the implied term. So a good example here is, you might remember it from your law days. We have this 48 hours a week, didn't we? You shouldn't work more than 48 hours a week. And then,
that would be nice.
And then the first thing you did when I signed my training contract is I instantly contracted out of that. That is an example of where you can override the statutory rule. And what we would advise our clients and anyone in this situation is you need to look at the statute. What does the governing law say? And normally it will guide you as to whether or not you can contract out of it.
And I think one thing we should say there is those particular instances where statutes prevail, actually, in terms of a normal commercial contract, they're very unlikely to be anything that would cut across the commercial agreement. It's typically things such as employment or sale of goods, where there are these specific statutes and specific standards.
So, I mean, if we carry on down that sliding scale, we've got statute at the top and then implied by fact.
So what gap is this trying to fill? And I think this could be something where we say, well, actually, there is a gap in our contract. We'd argue, well, we just didn't cover this one thing. We'll set statute to one side and say, well, statute doesn't apply here. So we're really going to the courts and saying, well, the facts of this case imply that X, Y, or Z should have effect here. What can the courts do in that circumstance? Well, they may imply a term into a contract to fill a gap in the contract's drafting, but the courts will never look to improve a contract. They will never look to change the commercial provision, or position rather, that the parties entered into. They're not so presumptuous. They assume that the contracting parties are sophisticated parties and they intended what they wrote down. So this area, implied by fact, whilst it sounds very attractive, it's relatively limited. It's governed by case law, and it isn't perhaps always as consistent in its application as it would be, because this is the courts looking at particular factual circumstances. Yeah,
exactly. I mean, they've set, you can go down, you can rattle off a long list of case law. They've set certain tests. There's something called the officious bystander test, the business efficacy tests, and there's been clarity from other case law on how to apply these. But I think, from a key takeaway, it's difficult and it's inconsistent. And probably the terms we frequently see implied in fact are things like good cooperation between the parties, that you're not prevented from doing something by one party, and the right to terminate an indefinite contract. These are things that the courts might say, well, they're so obvious that the parties must have meant for it to be implied by fact.
But one of the keys, again here, is that, as we mentioned, the courts will not change the substance of that contract. If there is an express term in a contract which expressly states something to the contrary, the courts will not cut across that. So here we see a difference between in terms implied by fact and in terms implied by statute. And in the latter case, the courts there will say statute cuts across perhaps that particular express term. And I guess the next one we should think about is implied by custom, perhaps, or previous dealings.
Previous dealings is, on the face of it, it makes a lot of logical sense. This is how we've always done things. Why shouldn't that continue to apply?
How do you prove that, though? Isn't that really hard?
It is, and that's why on our sliding scale here, there's a reason it kind of comes in last place, because courts in England are very hesitant to try and cut across anything that the parties may have agreed, and they don't want to infer terms into the contract. So there's a bit of case law here to help us out, and if you're going to rely on past practice, what we know is that saying something is market practice, that might aid your case, but that isn't going to be enough on its own. You need to show real, regular, consistent dealing on this past practice. So there's been a successful argument where the parties carried out several transactions every month over a period of, I think it was 2 years. There they were able to demonstrate that past practice was an implied term. So maybe if you have a regular payment of a bank loan, you've paid it every single day on the same first day of every month, consistently over 2 years, and then all of a sudden that changes, you've got a stronger argument. But 2 or 3 transactions every year isn't gonna cut it. So what happened here, there was a case of Hollier Rambler Motors. The customer gives his car into a garage, an MOT garage. The garage has an express waiver. In the event of fire, we're not liable. Surprise, surprise, there's a fire. The garage owner says, well, look at the sign. It says that it was at your own risk. But and you've been here before, and the customer was able to successfully argue, hold on, this wasn't expressly written into my contract, and I've only been here 2-3 times across a 3-4 year period. Past practice wasn't found to be the case. So I think overall, our advice would always be get it written down. And past practice, as you said, same with implied by fact, it will never be able to cut across an express term in the contract.
Exactly. So that's a quick canter through express terms and implied terms. And what are our key takeaways? Well, I suppose the one key takeaway is write it down. Say what you mean. Don't assume that the courts will imply terms in your contract.
Exactly right.
Thanks for joining us today, and we hope you tune in for our next podcast.
Thank you.
You have been listening to a Kumaran podcast. The podcast reflects our legal specialist view of the current state of the law. Please be advised that the state of the law is always subject to change as new case law emerges.